thank you so much for joining today's webinar on intellectual property, social media, and Google Ads, presented by Rana Moustafa, Associate at D&C Legal Services. The session today is brought to you by LexisNexis Middle East and D&C Legal Services. My name is Madly and I am from LexisNexis. I will be connected for the duration of the webinar to assist with any queries you may have or any technical difficulties you may experience. You will have the opportunity to submit text questions by typing them into the chat box or the Q&A box. It's usually found on the right-hand side of your screen. If you do wish to ask a question to the speaker during the Q&A, please click the raise hand icon so that I can unmute your mic and you can ask the question verbally. And in case you experience any technical issues, please check your connections, refresh your browsers if you are connected to one. If not, just pop me a message and I'll try and help you to the best that I can. Thank you so much for your kind attention and for attending once again. I am now going to hand over to Rana to start the session.
Thank you, Marley, for your introduction. And thank you, everyone, for joining us today with LexisNexis. I am Rana, as Marley said, from D&C Legal Services. And I'll be presenting to you today a very important and recurring subject in legal practice. The subject of our webinar today would be intellectual property, social media, and Google Ads. Hope you enjoy it. Of course, we all know how important social media is and how it impacted our daily lives as individuals, and as business owners, it impacted business as well. Social media is becoming king, and the culture of oversharing is becoming the new norm. And of course, with such impact, social media have allowed business owners to have opportunities to interconnect with their customers and to get inspiration even from others. And of course, with such emergence of social media platforms, we have seen how it impacted modern life rights, such as intellectual property rights. Our presentation today will be mainly talking about important subjects and would be answering some important questions, such as how intellectual property is protected on social media platforms, and how social media platforms have allowed intellectual property rights to evolve, and whether or not social media content could be considered as intellectual property right or not. I'm turning on, just bear with me. We will first try to identify today these topics and these notions we have briefly introduced now. And the structure guide of our presentation would be mainly focusing on two core sections. The first core section will be talking about social media content consideration as intellectual property. And the second core section will be mainly presenting to you the key challenges, the key issues, or the key changes that occurred to intellectual property rights with the emergence of social media platforms. We'll be talking about the key infringements you can meet as business owners, and the key considerations and prevention measures that you could take into account in order to avoid these infringements. Of course, we all may have a general overview or a general definition of what is intellectual property. But in order to have a better discussion around it, we will try today to framework it to the legal definition we usually refer to as legal practitioners. Intellectual property rights or intellectual property in general are referred to according to the WIPO or the World Intellectual Property Organization as anything that could be innovations of the mind, any creation, any symbols, elements, designs that could be used in commerce. What this means in practice is that intellectual property could be any creation, whether or not tangible or intangible. Of course, when you create something, you would be the holder of this creation, and with it, you would have the exclusive ownership of it. And of course, this is where it gets blurry with social media platforms. We will understand this later in our presentation, but for now, let's discuss what could be the definition of social media. Social media is usually defined as the interconnection of individuals on online platform or digital platform, and the exchange of user-generated content, data, or information. Today in our presentation, we will be referring to some specific social media platforms. For example, microblogging sites. This would be mainly Twitter. Social networking platforms. Of course, we all know Facebook for individual interconnections, and maybe for now it's becoming a commercial platform as well. And social networking could include as well professional networking. This would be LinkedIn. And as well, another important social media platforms usually is a multimedia platform is YouTube. Now let's move to discuss or to have an overview of the intellectual property rights that are present on social media platforms. Usually we refer to three main intellectual property rights that are the subject of disputes or changes: copyrights, brands, and AdWords. And AdWords would be mainly related to search engine platforms, more of social media platforms. Let's discuss now what could be copyrights and how are they defined, how are they present on social media platforms. Copyrights applies to a wide range of creative, intellectual, artistic forms or works. This could be, for example, videos, images, graphic designs, cinematograph films. It could also be computer software and website displays. However, we sometimes may fall in the confusion that copyrights include the ideas or the information themselves, or protects the ideas or information themselves. We would like to highlight today that copyright does not cover the idea or information itself. It covers the form or the way they are expressed. Now let's move to another intellectual property right, which is very important to discuss why we are talking about this subject, which is brands. The brand is what mainly defines a company's identity in the face of any customer, and this includes logos, brand names, design elements. However, not everything as well are protected on social media platforms. We have seen the important debate concerning brands. For example, personally, when I shop online, or you, for example, when you present a brand online, sometimes you will provide a customer service. And how your employees interact with customers, this is a particular aspect of brand identity. But what we don't know, or clients don't know usually, is that this form of how employees interact with customers is a form of brand identity. However, it's not yet protected by intellectual property rights, and it is a subject of a very important debate today on social media platforms. Let's now discuss Google AdWords. Of course, we have heard of Google AdWords throughout the years since 2010, and with its emergence nowadays, it's becoming a very important aspect. What Google AdWords is related, what it forms the relation with intellectual property rights is mainly trademarks. And we will try to present to you today the system of Google AdWords. Usually, Google AdWords function the way as follows. Search engine platforms, for example, Google, as we are talking about Google AdWords, they establish an advertising system. It's called AdWords. And with this system, while you personally or anyone enters on the search tab a keyword, whether it's branded keyword or non-branded keyword, and we will see this later in our presentation, you will have natural results. And these results will allow you to have access to advertisements. Why this system is very important to business owners? Of course, we will answer this by a simple answer. By matching relevant advertising content to the content on a publisher page, AdWords present a very efficient way for an advertiser to increase traffic on their website without having to purchase advertising inventory on other sites. And we will see this in a more clear way later on in our presentation. Now, after having an overview of the intellectual property rights that may be present on social media platforms, we will try to discuss the interconnection between intellectual property rights and social media platforms. This would be mainly covering the strategies, the policies that are presented by these social media platforms in order to protect intellectual property rights. We all may have experienced the step of logging in or signing into a social media platforms. We may remember the terms and conditions box that we always have to assign to in order to use the social media platforms. Of course, when you sign up for social media, this is considered a way of giving a license or a legal permission for the platform to use your product or material. And of course, this is necessary, but this does not override intellectual property laws. And this is a very important point to consider. And of course, as a creator on a social media platform or as a business owner on a social media platform, you would have a sort of an implicit agreement made between you and the platform. However, it's very important to remember that this does not mean that your content on social media is free. And this was the subject of many debates, because many people, many business owners or clients would consider that the content on social media is free. And this would lead us to a very important question, which is how free is free? As access to content is expanding in the digital world and on social media platforms in specific, the line between ownership, duplication, distribution has been blurred, and many people would think that everything on social media is free. And this is why we are presenting to you this subject, because it concerns this particular questions heavily. Of course, we have seen how social media platforms have dealt with this question and have tried to insist on the point that not everything is free, because this would lead us to many infringements. And contrary to popular belief, you cannot just take images or videos of others and use it as your own, because this would be considered as intellectual property abuse. And we will try to discuss with you today what are the policies that were provided by social media platforms, how they have been implemented, and how they will help you to protect your intellectual property rights. For example, we have seen Facebook, which is a social media platform, implement a very important policy. For example, as a user of Facebook, you would see the Facebook customer help or the Facebook service help. This is a very important point where Facebook have allowed the users to file a complaint once they hear that their rights are infringed. It would be mainly focusing and relying on the D&C Act, which is a DMCA Act, which is a very important act implemented by Facebook as a social media platform to protect your intellectual property rights. We have seen the same thing apply with Twitter, where Twitter have implemented a very important policy in order for you to file a complaint when, for example, someone uses an image of you or a video that you have created without your permission. And this is where the interconnection between intellectual property rights and social media platforms occurs, mainly focusing on the implementation of policies, guidelines for you to abide by and for others to abide by. Now let's see every intellectual property right and how is it protected on these social media platforms in a more specific way. For example, for copyright protection on social media, we have seen a very important point. Copyright protection on social media revolves around mainly two aspects: protecting the user's content and protecting the content of others. Of course, the content creator on social media would be the copyright holder, as we earlier said. And for you to be a copyright holder, you would have to abide by certain conditions. These conditions we will be talking about today are mainly two conditions: that your content is original and the content satisfies the threshold of originality. Of course, copyright protection on social media is not easy, and with it may come important disputes, important issues. And we will today highlight and present to you some important changes and some important disputes that happened concerning copyright protection on social media. For example, one of the cases that were really interesting for us as legal practitioners was the LeBron James case. The LeBron James case was one way or another connected to copyright protection. What happened in practice was that LeBron James, we may know him, he is a basketball player, and while he was playing during the match, a famous photographer called Mitchell took a photo of him while he was dunking. And what happened later on is that LeBron James posted his picture on his own personal accounts, on a Facebook account, Instagram account. And what happened is that the photographer filed the case against LeBron James for infringement of his rights, which was mainly the unfair usage of the photo without the permission of the photographer. Actually, in this case, it was ended by settlement agreement in favor of the photographer, because it was an established principle that for any person to use the creation of another person, he should always have permission for it. And we will see this later in our second core section. Another important aspect of copyright protection on social media platform was fair use and influencers. We have seen nowadays many influencers, many individuals who are entitled as influencers, who would sometimes be referred to by brand owners, famous brands, in order to promote their products or services. What has been applied in many countries and in many intellectual property laws is a very important thing to say today. Social media influencers will need nowadays to ensure that they have proper permission before using the creative works of others in videos, images, or media posts. This is a very important change because we have seen, for example, in a GCC country as UAE, who have implemented a very important rule that influencers would have to abide by having a permission before posting anything or promoting for his service. And this is very important because it would, if they don't have permission or if they don't abide by these rules, they would be qualified as copyright abusers. Another important change that occurred for copyright protection on social media platform is YouTube Content ID. What this system is doing in practice is that it implements copyright owners to have a system or an ID in order to identify or manage the protection of their content. Whenever a content, for example, is uploaded on YouTube, you will have the capacity or the facility to use your content ID in order to scan the new content to check for the matches of copyrighted content already present. And with it, you will understand whether or not your content has been infringed or used by another person. Of course, not only copyrights are important on social media platforms, brands as well, we have seen and we have presented to you earlier, are very important on social media platforms. And the way they are protected as well shows this importance. For example, we have seen how social media markets have implemented enforcement tools, have implemented protection tools in order to facilitate for brand owners to have their brands on these marketplaces without being infringed. For example, Amazon and eBay, they both launched tools which allow brands to easily upload their IP documentation, to use them to report or remove anything that is related to counterfeit products or anything that could be considered as counterfeits. Of course, this is a very important step in order to protect your brand, and it facilitates your presence on social media platforms or on online marketplaces without risking your brand being infringed. And of course, we have a very important note to discuss today, which is that brand owners may need to explore the need to register a unique hashtag slogan. We have seen how hashtags have been functioning these days and how they are representing a very important part of brands. And with this, the hashtags should be protected, and with it you would be having a more unique presence, you would have a more protected presence without risking anything. Of course, not only intellectual property rights revolving around brands or copyrights are the subject of our presentation today. We have seen how trademarks are linked to AdWords and Google AdWords, and how they are impacted heavily. We will try to discuss now the system of Google AdWords, which is mainly focusing on enabling any economic operator to use one or more keywords in order to help have an advertising link to its website. Of course, Google sponsored link has the following structure, as we can see on the slide. It's a hyperlinked text that would lead to the advertiser's site, which is called, of course, an ad. And an ad disclaimer would be present next to the advertiser website. And finally, a commercial text. What this means in practice, that when you enter, for example, any keyword on the search tab of Google, you will have a list of advertisements. And the one who bids the most will have the most present advertisement. We will see this in a more clear way later in our presentation. Now, let's head to very important questions that are occurring today when talking about AdWords. The first question would be, who can bid on your branded keywords and trademark terms? The second question we'll be talking about would be, can anyone use your trademark in their ad copy or not? We have seen how AdWords have impacted many purchases, many brand profits. And throughout the COVID-19, for example, period, we have seen how people would tend to have online purchases, have online interaction with their brands in order to get anything. And this is heavily related to the emergence of social media platforms and what search engines today, like Google, are allowing. Of course, in one of the cases that was related to Google AdWords was the Google France SARL versus Louis Vuitton. This is a very important case. Why? We are presenting it today because it's related heavily to the question of how trademarks are impacted by Google AdWords and the Google AdWords system in general. In this case, for example, the ECJ, which is the European Court of Justice, it was held that an advertiser which acquires the trademark of another third party could be accused of trademark infringement if And this was upon a condition, which was that if the user or the advertiser is using the trademark in a way that asserts a certain confusion for the internet user, whether by thinking that the goods or services or products in the ad are the products of the trademark owner, this would be considered as trademark infringement. Why this case is important? Because it shows us how Google AdWords trademark policies could be sometimes confusing and most of the time are in the side or in the favor of the advertiser or the person or the entity that would bid the most on the product and not in favor of the trademark owner himself. And this is important, and we will see why later in our presentation when we talk about the protection measures. We have to, while discussing Google AdWords, present to you a very important differentiation, which is the differentiation between branded keywords and non-branded keywords. What are branded keywords? Branded keywords in general are the literal brand names. For example, when you enter on the search tab, Nescafe, for example, this is a keyword. This is a branded keyword. And what is the efficiency of this branded keyword is that it would allow you to get the right audience, of course, because it would be directly heading to the audience you need. And on another hand, non-branded keywords are more related to keywords or phrases, sentences that would include the branded keyword. Of course, this is less likely to be profitable because it would be not heading directly to the audience you need. And this differentiation leads us to answer the two questions we have presented to you regarding this subject. The key questions regarding AdWords on social media, as we mentioned them, the first question, just to remember, was who can bid on your branded keywords and trademark terms? Of course, we have seen how Google wants to facilitate the flow of information and e-commerce services with their search engine. And we have seen how many of our clients would assume that they are the only entities or that they are only brand owner who can bid on their branded keywords or trademark terms. However, this is completely wrong and completely irrelevant, because the truth is that anyone could bid on your branded keywords and trademark terms, even your own competitors. This is, of course, a very important point to highlight, because it may sometimes let you face some disputes and debates. The second question we are talking about today related to AdWords is, can anyone use your trademark in their ad copy or not? Of course, the rules or the Google AdWords rules are different for different regions. For example, we have seen how for regions in the concerning the United States, Canada, or the Commonwealth regions in general, the Google AdWords system is more flexible, on the contrary to the system in the European region, which is more restricted, and we will see this specifically now. For example, in the United States, Canada, United Kingdom, and many Commonwealth countries or common law countries, we have seen, for example, how resellers can use the trademark in the ad copy as long as the ad's landing page is primarily dedicated to selling products or services corresponding to the trademark. On another note, for example, informational sites, they can use trademarks in the ad copy only upon a condition, which is the primary purpose of the ad's landing page is to provide, of course, informative details about products or services corresponding to the trademark. The contrary is present in the European Union and European Free Trade Association regions. For example, the rules are more restrictive, as I said, and they are focused on eliminating consumer confusion, unlikely what is happening in common law countries. And what Google is trying to implement in this particular regions is, or the European region in specific words, they are trying to implement rules related to investigation that would help any brand owner to disapprove or to file complaints in order to get their rights back and to avoid trademark infringement. Now, after presenting to you how social media content could be considered as intellectual property rights, and after having an overview of the intellectual property rights in general, the different policies and guidelines, we are now interested to discuss with you the key infringements, the key disputes that you may meet while being present on social media platforms. And we will later on provide you with the key considerations, the key protection measures that you should take into consideration. Now let's start by talking about the key infringements. Of course, after we have seen how social media is king in business, social media is as well a host of challenges. The practical threats to your business intellectual property could be met in different ways on social media platforms. And of course, the protection is better than the cure. This is why we'll be discussing the key infringements for you to know it. For example, first infringement that you could meet is simply your intellectual property being stolen. As much of the content on the web is easy to access, it can seem to many people that it's free to use, as we mentioned in the question of how free is free. And you can easily get your intellectual property stolen while, for example, people having your creations, your posts used without your permission, as we have seen in the LeBron James case. And another important infringement would be you using copyrighted material. You may explicitly or implicitly, being aware or unaware, use in a copyrighted material of others. This is why it's very important to consider having permission, having everything in place before using anything that is related to creation of another person. Another key infringement would be the unlawful use or distribution of content. This could be distribution of a text, a photo, or video, and this can potentially result in irrevocable damage corresponding concerning your business or your brand, and it will heavily impact you and lead you to unnecessary disputes, unnecessary court procedures that you would need to avoid. Of course, another key and a very important infringement that you could meet, which is offering counterfeit goods on social media platforms. We have seen, while examining this particular topic, a study entitled Social Media and Luxury Goods Counterfeit. What this study included in specific is that around 750,000 Instagram posts for luxury fashion brands have been found and established that 20% of these brands or of these products are related to counterfeit and illicit goods. Of course, this is a very important percentage, and it shows you how offering counterfeit goods on social media platforms is becoming more and more recurrent and should be heavily considered. One of the more important key infringements is copyright violation, unfair competition, and false endorsement. And we will provide you with another case that we have examined. It's called the Volvo's case. This case was particularly related to unfair usage of copyright material, unfair competition, false endorsement, which was brought up by a photographer and a model he photographed. Of course, we all know Volvo, it's a car brand, and the model and the photographer was doing work for this company. And what happened in practice is that Volvo used the copyrighted material without permission. Just the same thing that happened in the LeBron James case. And what happened is they also did get damages because of the unfair usage and unfair competition that occurred. Of course, this shows us how this infringement is very important today and is heavily considered by courts. Now, after presenting to you the key infringements, we will be glad to present to you the key misconceptions of copyrights on social media. These misconceptions may not be considered as infringements, but they are misconceptions which should be clarified in order to avoid them as well. For example, we have met many clients who would consider the following. For example, giving attribution and linking back to the original work would protect us from infringement. This is a very important misconception that should be taken into account. This is, it should be understood by everyone that giving attribution and linking back to the original work is not sufficient, and you should always have permission. If you don't have permission, it would be automatically constituting a copyright infringement and a copyright abuse. And we don't want this to occur, so the attribution is not sufficient and should be taken into account of having permission as well. Another key misconception is we would meet clients who would say, for example, that the owner clearly meant for anyone to use it. They posted it on social media. No, this is wrong, because when you put content or work online, it doesn't mean it loses its protection. And we have seen this earlier in our presentation. It might be easier to copy, it might be meeting a lot of risks, but it's still protected. Another key and very interesting actually misconception would be mainly the statement that this work has minimal creativity and probably not protected by copyright. This is a false assumption that should be taken into account. Everything that is put on social media may or may not have creativity, but most likely it would have minimal creativity, and with it, it would be protected. So it's very important to understand that everything that is on social media is protected. Another misconception is that if the owner complains, I can just take it down. Of course, this is a very good idea and it could be workable. However, you could meet with it very important problems, very important disputes that are unnecessary. So why do it in the beginning? You could always assume that the work is protected in order to not have aggressive copyright owner who can ask for damages for the copying of their work, or entering into disputes or court cases that could take a lot of time and could take a lot of costs and expenses, and it would lead you to heavily being burdened. Another aspect of infringements occurring on social media platforms would be trademark infringement. And this is mainly related to Google AdWords and how the system is functioning. For example, we have seen how Google AdWords could be infringing the trademarks rights. This would be mainly when as we have seen in the case of Google versus Louis Vuitton, when a company or another competitor would use your own trademark as their own and would confuse the consumer or the customers. Or, for example, for competitors who would bid and bid and bid more on your trademark in order to have the best advertisement. And of course, we have seen how Google is treating this particular aspect. And most of the time, Google would win in, for example, in cases where it would be, where Google would be a disputable party. We will understand now how Google AdWords would be causing infringement in particular. For example, if more than one person bids for the same AdWord, Google will be ranking the sponsored links according to how much the advertiser has bid for the AdWord. And this is called the cost per click. And of course, Google's own quality score for the advertiser's website would be mainly relying on this cost per click. The problem for trademark owners, and the reason why many trademark owners object to Google AdWords program, is that the more successful your brand, the more that third-party advertisers would be willing to bid for your trademark, and the more you will have to bid for your own brand as an AdWord to ensure that your sponsored link appears ahead of the third party's sponsored link. This is, of course, a very important point. However, it's still debatable, and it's still subject of many objections, of many disputes that many brand owners and trademark owners are trying to resolve. For example, recently we have seen how Google informed users that it will change the brand protection policies on its text adverts. And what this means in practice, that any distributor can use the brand name with the same conditions as you. This, of course, is a very important statement from Google's side, and we have seen even a more important statement where Google has announced that they won't investigate or restrict trademarks as keywords. This is, of course, was leading to many important disputes where the subject of Google AdWords have been addressed. For example, we have seen recent High Court decision on the question of whether a party acquiring and using similar or identical Google AdWords to another competitor's trademark, whether this constitutes an infringement of intellectual property in the trademark owned by the competitor or not. Of course, the High Court's position was that the AdWords are not seen by the public when they enter, for example, a search request, and therefore the public are not able to link the use of the AdWord to the registered trademark. Of course, this shows us how Google would always win in the cases, and how trademark owners have rarely won in Google AdWords cases because of this principle that was announced and declared by the High Courts, because there is no evidence that the internet user sees the use of the AdWord as they have no access to the algorithm of Google. This is the principle that is applicable today, and it's the subject of many infringements, many disputes. This is why we will provide you later on with protections that would help you avoid this particular point. Of course, another important aspect that we would need to talk about when talking about infringements of Google AdWords, or the infringements that may occur under the umbrella of Google AdWords. The key exceptions related to Google AdWords are important to highlight. And the following types of ads could be using a trademark term, however, it would not be considered infringement. For example, ads using the term descriptively in its ordinary meaning, rather than in reference to the trademark. For example, Apple, we all know the brand, is a trademark term. However, an online grocery store, for example, can refer to an apple in their ad text easily. Another important exception is that ads referring to goods or services that do not in a way or another correspond to the trademark. We have given you the example of Uber Conference versus Uber, which is the rideshare app. This particular example shows us how Uber in their name is referring to different goods and services, but they are both companies who are using Uber in the ad text without any problem. Now let's talk about key prevention measures and considerations for you to take into account in order to avoid any intellectual property infringement. We'll be providing to you now a protection guideline based on several points that we would like to highlight. For example, first protection measure would be blacklisting on Google Ads. The blacklisting measure is allowing you to have a certain protection against third parties' infringement. It would allow you to have authorized resellers. It would allow you to select and understand who are the people who are infringing or breaching your trademark, and it will allow you to have a blacklist for them. Of course, with this, you could always consider requests from third-party resellers very carefully if you are selling goods under the name directly from your website, and rely on Google Ads to drive traffic. Of course, another protection measure that you should take into account, that when you spot an infringement of your trademarked IP on Google Ads, you can always submit a trademark complaint to Google in order to review it and to help this be taken down. Another key point of the protection guideline would be, as easy as it may sound, knowing your rights. Of course, when infringed, you should always make a trademark complaint. You should always wait to receive confirmation of the complaint filed, and you would, with it, authorize certain specific advertiser accounts. If after doing all these steps, you are still meeting infringement, or you're still dealing with a certain violation of your rights, you should always reach an expert in order to help you file a case or start a procedural case practically. And of course, when starting a procedural case, you should always understand that you would have to prove some points, and several factors would be included. We are highlighting today 3 important things that should be subject of proof and would be burden of proof on your side if you are taking the choice of starting a court case. The first thing would be proving intent. You must prove, of course, that the third party who breached your right was intending to mislead the consumer by using keywords. And of course, you should prove actual confusion. And the actual confusion would be mainly relying on having to include actual proof of consumer confusion that happened as a result of the keyword advertising. And another last important point would be proving consumer sophistication. And this is related to whether those who see the keyword are members of the general public, or are they potential customers searching for your brand or product. The third point in our protection guideline is social listening to catch infringements. Social listening is a very important tool today, and a very important protection tool. This means that the use of digital tools would be mostly reliable and would be mostly leading to have protection. How the protection will be implemented? By social listening, you will have, for example, a tool to monitor online activity. You would be listening to keep track of customer complaints. You would be identifying marketing opportunities. With it, it would be useful for you as a brand owner or a trademark holder to use these tools or these digital tools to monitor your activity online. And of course, we have seen, for example, a social listening tool like Google Alerts. It's free and very simple. Or Mention, it's another digital tool which are very used by marketeers in monitoring their trademark and brand names. And it's said to be very efficient because it enables you to have a rapid response to cases of trademark infringement. Another useful measure is setting up reverse image search alerts. Of course, this is another tool that would help you have protection. And by this tool, you can find out when someone else has posted an image you own, or it would help you catch gray market resellers using your product and brand imagery. It's proved to be efficient for brand owners and trademark holders. Another fourth important point in our protection guideline is to focus on content best practices. What content best practices are mainly referring to is the content standards, or what are the current standards used in practice that would allow you have protection measures. For example, one of the business standards that were implemented and you should always aspire to have is to have a proper use of trademark symbols. For example, when someone is using, when you are using your trademark symbol or service mark, you should always discuss previously, and you should always have a certain way in implementing the proper use of your trademark or symbol. You should always make sure that not other people are using the same trademark. You should understand how to use it correctly, how to, for example, set out guidelines or documents that or bylaws that would help you implement the proper use of trademark symbols. For example, if you have partners or other affiliates. Another key standard would be to take appropriate measures if your brand is abused by cyber criminals. Of course, having a process in place for communicating brand-related security threats is a must for brands who have a large presence on social media platforms. Now, after having a general overview or a general protection guideline, we would be glad to present a practical legal guideline. There are legal prevention measures that should be taken into consideration in order to avoid any infringement, in order to help you have protection with legal presence and legal grounds. Mainly, there are 3 steps. And the first step we'll be talking about now is trademarking your company's name, logo, and slogan. Of course, this is a very important priority, and we always advise to have a registration of your trademark automatically in order to avoid any infringement. And of course, even if you are not planning to be present on social media platform, or you are not planning to be active, you should always, despite all this, register your trademark. Remember to proactively register your trademark name on top social media channels that we discussed earlier in the presentation. And of course, by this procedure and by this step, you would be one way or another reserving your name. You will have it available for you should you decide to market or connect on social media platforms. And you would be guaranteeing for yourself a protection. Another second step, which is a very important legal prevention measure, is to take action if infringement occurs. Of course, as legal practitioners, we would always insist on the point of reaching experts, of taking immediate or automatic action when your infringement occurs. Of course, if you do see evidence of infringement on a trademark you own, you should always head to an expert. You should always file a complaint. You could start it by having a complaint on the social media platforms with the help center. If you don't see any results, you could always lead to court procedures. The third step regarding legal prevention measures would be prior implementation of pacts and agreements. This would be mainly implementing competitive pacts, which some industries and some business owners have implemented effectively. And what this constitutes, in fact, is that written agreements are listed in detail, and they would allow business owners who have competitors to enforce proceedings if their rights are violated, or they meet any infringement of their rights. Another important pact or agreement would be affiliate agreements. If you have, for example, affiliates or partners, your affiliate agreement would be detailing how how certain things or certain activities are disallowed, what to do when your rights are breached, and you would have a very important legal tool or legal evidence that that your intellectual property is protected. After finalizing this legal prevention measures and this particular section, we have finalized our presentation today for you. Thank you so much for your attention. And if you are having any questions, you could always ask us or ask directly LexisNexis.
Perfect. Thank you so much, Rana. I do believe, though I think it's more a comment. No, it's a question. So I'm going to read the question that we received in the chat box. I'm not sure if you saw it, but it says, looking at the high statistic of complaints and reported cases to Google, not to waste court time, cost and resources, etc., etc. How could Google be able to promote and encourage mediation to parties as a solution? So I don't know if you'd be able to answer that question.
In fact, Google, as we have said, thank you, Marley, for saying the question. In fact, as we said today in our presentation, of course, Google is trying to implement some rules or guidelines for the people who are using Google AdWords, but Google is allowing only filing complaints or filing an online taking down, for example, of an advertiser. But for mediation or dispute resolution actions, they could always be used by parties in order to help have a better resolution. But Google would not specifically encourage mediation or otherwise.
Okay, perfect. I think that's all the questions we have then. So Rana, I want to thank you for presenting a very insightful session. I learned quite a few things. I especially found the LeBron James case very interesting, so thank you for that. To everyone connected, D&C Legal Services details are available on screen, so please feel free to reach out to them if you've got any questions. Alternatively, you can just get in touch with me directly and I'll pass any questions you may have over to Rana. Other than that, I want to thank you all so much for your kind attention today, and I am wishing you all a lovely day and also a lovely holiday should you be taking some holidays over the next couple of weeks. Thank you so much.
Thank you, Marley, and thank you everyone for joining us today. Hope it was useful, and have a lovely day.
Thank you. Just to add, yes, we will share the recording once it becomes ready.
Thank you.
Thank you. Bye-bye.
Bye.